Good afternoon and welcome to our webinar series, State of Probate in Georgia, How the Pandemic Changed Things. I'd like to mention a couple of upcoming chapter events. We've got a webinar series, The Referral Generating Machine, on March 5th from 4 to 5. A webinar series, Streamlining Vendor Risk, Practical Approaches that Meet Regulatory Requirements, on April 17th from 12 to 1. And last but not least, our annual regional symposium on May 1st from 8 to 5. Discounted early bird rates are available now. Please check our website for updates, details, and register today. We are thrilled to be joined by Mark Brandenburg. Mark has 20 years of experience in estate planning, estate administration, and probate law. He graduated from Emory Law School in 2005 as a member of the Moot Court team. Please submit your questions via the Q&A feature within the Zoom controls at the bottom of your screen. And with that, I'll turn it over to Mark to begin.
Thank you very much, Kathy. It's wonderful to be here with everybody. I wanted to also share a little bit about the beginning of my career, which was when I graduated from Emory Law School. I went to work for the probate judge in DeKalb County, and worked for Judge Roche for 5 years, from 2005 to 2010. And although that experience is now pretty far in the past, it has colored my point of view in this presentation. So I wanted to make sure that that was known to all listeners. Let's go over an agenda of what I'd like to cover this afternoon. I'd like to begin with what is probate. In the event that you maybe don't know anything about probate, or you just know a little bit and need a refresher, let's talk about what it is. Then I want to talk about how probate impacts your clients. We're going to kind of get into a little bit of depth there as to what probate means for the clients you serve. Next, I want to talk about probate in the pre-pandemic era, which would have been before 2020. And then the post-pandemic era that we're in now and how it's changed. We're going to go into current methods to avoid probate. Some of these may be familiar to you, but it's a good idea to get refreshed on them. And there may be a couple in there that are new to you. And then we're going to finish with the future of probate in Georgia. What we're being told about what the future will look like, and what I think the future may look like as well, to send you off on your way. And I would welcome questions. I'm going to take questions at the end of the program, but you can go ahead and put them in the Q&A bar when you think of it, and we'll get to those at the end. All right, let's begin with what is probate. So probate is a court system in the state of Georgia. Most other states have a system. It might be called probate, it might be called something else, but every state in the country has a system that does what our probate court system does. And every county in Georgia has a probate judge that sits in a courthouse that manages the responsibilities of the probate court. What are the probate court responsibilities? Well, primarily is to administer wills and estates. They're responsible for holding wills, making sure that they're valid after someone dies, to potentially oversee or supervise the administration of an estate, making sure that the executor does the job properly, and enforcing the other laws that the Georgia General Assembly has put in place for what's to happen at death with assets that are governed by the probate court. Another responsibility of the probate court is to appoint and oversee guardians and conservators. Guardians and conservators share, if you don't know, they share a role, which is that they're responsible for somebody else's decision-making. Guardians are responsible for healthcare decision-making of someone else. Conservators are responsible for the financial decision-making of someone else. You could be a guardian and conservator for a minor child who is under the age of 18 and needs someone making decisions for them, or you could be a guardian and conservator for an adult who has lost the capacity to make their own decisions regarding healthcare and finances. All the probate courts in Georgia also do a couple other things. They issue marriage licenses. So if you want to get married in Georgia, you need to go to the probate court and obtain a marriage license so that you can do it properly. They also issue weapon carry licenses for those who want to carry guns outside their home legally. Some of the probate courts also do things that that you may not have expected. For example, these next few items tend to be in the smaller counties in Georgia, not in the major metro Atlanta counties, for example, but they adjudicate traffic offenses. They hear misdemeanor criminal cases. They may handle the vital records, whereas in the Atlanta area, of course, we have a vital records office that handles death certificates. Perhaps in a small county, the probate court does it. And then in some counties, they actually are the supervisor of elections. So they have quite a few responsibilities that are added on to what they initially were created for. And sometimes those things can start to get in the way of each other. All right, but at its core, the probate court is there to protect those who cannot protect themselves. Okay, a deceased person can't stand up and say, that's not my will, or cannot stand up and say, I don't trust my brother to be in charge of my assets. I didn't want him to be in charge. An incapacitated person, whether that's someone who's a minor because they're under the age of 18, or an incapacitated adult who had an injury or an illness, they can no longer stand up and say, I don't want these people to be in charge of me, or I do want this person to be in charge of me and to do certain things. So we have this probate court system that protects those who cannot protect themselves. And in doing that, they also limit chaos. We could have chaos if there was a death and we didn't have any way to determine if two wills that are being offered as that person's last will, if we didn't know which one was which. We could have chaos if a person died without a will. Who among their family and friends and community is the right person to be in charge of their assets and pass them on to the right place? We didn't have a forum in which to address those questions and ultimately have a judge who decides those questions. We could have chaos. Also, if a person dies without a will, then there is a set of laws in Georgia as to who is to receive those assets. If we didn't have a court to enforce those laws, we could have a problem. As you know, probably that for many cases, if you die without a will, your spouse is to receive your assets. If you have children, whether they're minor or adult, they also share with your spouse in receiving assets. So we need to make sure as a community that we have those laws enforced so the right people are notified that they're about to receive something and are given the opportunity to step forward and receive. Also, if there are grievances related to an estate, perhaps an executor has been appointed but hasn't done anything and it's been 2 years since they were appointed. We need a forum where the beneficiaries of that estate can come forward and to the judge and complain. Of course, complain, it's in a more formal manner than that, but we'll just, for our purposes, we'll call it complaining. There are also a forum for competing wills, or maybe there's one will that's presented only, but it is potentially the product of fraud or undue influence or forgery. We need a forum where people can come forward who know that that's not an accurate will and say something about it. Now, when I mention the probate court and what it is, I think it's important, and I know many on this call already are going to appreciate this, that it's important that we talk about what is a probate asset and what is a non-probate asset. And for this slide, I want to look at it from the approach of death. Okay, so even though I talked about some other things the probate court does, let's talk about death. What are probate assets and what are non-probate assets? If you happen to have a non-probate asset, it is not governed by your will. It's not governed by the probate court in any way, even if you die without a will. It's completely separate from the probate court system. So I think it's best to look at what is a non-probate asset first, and then we'll back into what is a probate asset. So a non-probate asset is something that is jointly owned, that you own with someone else. It could be your house. Many times a married couple own their house as joint tenants with rights of survivorship. It could be a joint account at the brokerage where you work, for example. Husband and wife or spouses have a joint account together. Sometimes it could be a parent and a child, an adult child, have a joint account together. Not always my preference that your clients are doing that, but that we'll talk about that another time. But anything that is joint, when one owner dies, as you probably know, the surviving owner remains the owner of that asset. And that happens as an operation of law. It doesn't require a will to be probated, and the probate court has no control over it. Another non-probate asset are retirement accounts, pensions that your clients have. Those, as you know, have beneficiary designations attached to them, as long as those designations are updated so that the right people are still living and that there's a place for it to go, then that's all going to go according to the beneficiary designation, and the probate court does not get involved. Same thing with life insurance. That also has a beneficiary designation, so it goes directly to who the deceased wanted it to go to. Does not matter what their will says. And then lastly, our transfer on death accounts, which I'm sure you're familiar with as well. Another non-probate asset is an asset that's inside of a trust. All right, we're going to talk about that in a little bit more detail later in the presentation, but if an asset is in a trust, then it goes according to the trust instructions. Doesn't matter what the will says or what a probate court says. Okay, so what is a probate asset? A probate asset is everything else. All right, so think about it as something you own individually, something that is not a retirement account, is not life insurance, and is not owned inside of a trust. It could be a car, could be a checking account, could be a brokerage account, could be the home furnishings that you have inside your client has inside their homes. Those are all probate assets, and those are the things that the probate court and will are going to have jurisdiction over. Okay, so with that lens of what is a probate asset and what is not, let's stay focused on probate courts and those assets that it governs. So how does probate impact your clients? The word probate actually comes from the Latin verb of probare, which means to prove. And that's really the core of what the probate court was established to do when it was created, was to prove that a will is valid. And the way to do that in Georgia is that there are steps that are taken to probate a will. For example, if a client of yours dies and they leave a spouse behind, and the spouse has a will that they need to utilize, perhaps that spouse would hire a lawyer like me to prepare a petition that's filed in the probate court of the county where that individual died. Okay. The petition says, if you haven't seen one, I'll go through it real briefly. The petition says who died, the address they lived at, the date of their death, who their survivors were, as far as their survivors being the heirs at law, which can be different depending on each person's family circumstances, and who was alive at the time of their death. But for example, if this deceased had a spouse and children, then the heirs at law who get notice of this petition are the spouse and children. The petition must also include the original will. It must be the wet signature that the person signed when they signed their will. That's, of course, outdated, but the law doesn't seem to be changing on that one. So you have to have the original. In fact, if you don't have the original, Georgia law says there's a presumption. The presumption is that the testator, the one who died, had destroyed that will. and did it purposefully because he didn't want that to be his last will and testament. There is a way to overcome that presumption, but it can be challenging. You have to present facts that demonstrate that the will was destroyed in the fire that also killed our testator, for example, not just we can't find it. So the spouse comes to me, we file a petition to probate the will. We have to serve the heirs, or if the heirs are cooperative, we can have them sign in front of a notary. And as I said before, the heirs are commonly the spouse and the children. If the children are minors, under the age of 18, then the court is going to appoint a guardian ad litem to represent those minors in this matter. The guardian ad litem is usually a lawyer who's appointed by the court to review the petition we filed and to determine whether this will its probate is in the best interest of the children, and if there's any facts that would indicate it's not the last will and testament of the deceased. The court will review the petition, the will, the guardian ad litem's answers, if there are any, and will determine whether the will is valid under state law. Does it have the right number of witnesses? Did the testator sign it properly? And so forth. If there are uncooperative heirs or heirs who don't respond at all, then they're given an opportunity to object to the will and to the fitness of the executor. And the court will hear those objections through a trial. So all it takes is one unhappy heir to send in one piece of paper that says, I think this will is fraudulent. And suddenly the court is going to stop everything, is going to give the parties who are now in a dispute 6 months to exchange discovery. And then hopefully not too long after that 6 months, there will be either a bench trial or a jury trial. So all it takes is one person to really gum up the works. But let's say there's no one who's being uncooperative and everybody is coming together and sign the right things and we probate the will. At the end of that process, the court is going to issue a document called letters testamentary. And that is the beginning of the executor having a fiduciary responsibility to handle this estate. And one of the first things they have to do is notify creditors. And they notify the creditors that this estate is established. So if there are any debts that are due, that we know about them. And there's a relatively new law that came out about a year or so ago that now says the executor has to notify all the beneficiaries as well. Not a very popular law in the fiduciary section of the bar, of which I'm a member, but we're now required to send a notice to all the beneficiaries in case they didn't know they were about to receive money that there's an executor appointed. Usually, what's not popular about it is usually they already know, and it's an unnecessary step. Okay, so the advantages of the probate court system. It's useful for those who did not plan. If a person didn't have a will and then died, we would have complete chaos if we didn't have a set of laws in Georgia that identify who is to receive their assets and a system for how to get a person in charge of handling those assets and handing them over. The probate court is also, even if you die with a will, it's also useful for those who have a will but maybe didn't plan to try to avoid probate. It's another advantage is it protects those who cannot protect themselves. There are marginalized members of our communities who need a system to make sure they're not being taken advantage of, whether it's because they're elderly and have lost the ability to make decisions, whether it's because they're under the age of 18 and were awarded a settlement due to a dog bite that injured them. But we don't want this child's mother to use the settlement to pay for all the other children in her household. This money should be saved for medical expenses and college education, perhaps. So the other advantages, of course, is they can limit chaos in a variety of different circumstances, like the ones I just described. So there are some advantages to the probate court system. I'm glad we have it. But there are some serious disadvantages to the probate court system as well. And these disadvantages have been there before the pandemic. So we're going to go into, in a few moments, we're going to go into a little bit more detail about what's changed. But the disadvantages have always been there. Some of them have gotten worse. There are government delays. Okay, when the spouse comes to me and we file a petition to probate a will, there is going to be a delay for the government to just get to reviewing that petition. And I'll go into more detail about how long you might want to expect that to be. But there's not only the government delay at the beginning, there's also government delays through the process. If you have a question, or if they have a question for you and you need to communicate with them, it can take days, maybe longer, for you to get a response. Sometimes they don't answer the phone. So things don't move as quickly as your clients would wish them to. Another disadvantage is that it's public. So nearly everything that goes on in the probate court is public. They do seal mental illness matters, and they seal incapacitated adult and children matters. But the majority of what you're thinking about when you think about probate has to do with wills and estates. Those proceedings are all public. So the will that was a private document all the way until someone dies suddenly becomes a public document. And that petition that we have to file to get the will probated also becomes public. Any objections become public. So there's a loss of privacy, perhaps, as a disadvantage. Another disadvantage of being in the probate court system is that the judge is the ultimate decider. Even if a person left a will saying who they want to be as executor and a line of succession as 1, 2, and 3, who they want to follow that first choice, ultimately it's the judge who decides. I don't have many circumstances where I can describe that a judge just unilaterally decides to appoint someone different. But I have many experiences where, when there's a dispute because one family member doesn't like the person chosen, or 2 people were chosen to be co-executors and they don't seem to be getting along, and they find themselves in court saying, "Hey, judge, we need some help. We can't work this out." Very often the judge is just going to take everybody out that's a family member and appoint a third party that is a professional at doing this kind of work, which is not always what the executor wanted, not always what the testator had wanted, and may slow things down even further. If a professional is appointed, that professional will receive a commission, whereas a family member will often serve as executor at perhaps for no commission, because they're most often receiving a benefit as a beneficiary as well. A professional is certainly going to receive a commission. Another disadvantage of the probate court is there's a greater potential for disputes. You've got a will, or perhaps no will, and you're required to notify the family members of this existence, either of a document or of no document. And particularly disgruntled family members, even if they've been disinherited, they're certainly disgruntled, but they're going to get notice. If we're talking about a less traditional family dynamic, where maybe it's not a spouse and children who die, who are surviving, maybe it is a single person who died, and we're notifying siblings, or parents and siblings. Those all may come forward and say, "Hey, I think I'm going to object." So there's an opportunity, there's a forum for disputes in a probate court's environment. And then lastly, the default is that the probate court is going to supervise the executor who's in charge of the estate. And that may mean that the executor has to file an inventory 6 months after they're appointed. The executor has to file an annual return, which is a accounting of how they collected and spent money over the last year on behalf of the estate. The executor may have to give a bond to the probate court equal to the value of the assets that it's in charge of. In case the executor turns out to be a crook, then the bond will protect the beneficiaries from loss. Now, many wills will waive the right, waive the responsibility that the court supervise. And there are other ways to waive that supervision, but the default is the court is going to be very involved in this estate. And that can sometimes be a burden on those who don't need that kind of oversight. All right, so moving on to another item on the agenda is, what was probate like pre-pandemic? Okay, I worked in the probate court, as I mentioned, in DeKalb County from 2005 to 2010. And then went into private practice. I, of course, experienced the probate court for those 5 years. In fact, my role there was to be the judge's attorney. So I was her staff attorney. So I managed the staff that worked at the court and helped them with legal challenges that customers, is what we called them, which would be members of the public, would come in and present to them, and I would help them figure out what to do with those. I also was the judge's law clerk, so I was involved in helping her make judicial decisions. So I got to know that court very well in those years. For the next 10 years after I left the court and before the pandemic started, I worked in private practice at two boutique firms in the Atlanta area. And I learned how to do estate planning from lawyers who are either mostly retired now or are getting close to retirement. So I learned from the previous generation. And I was taught that Georgia was a probate-friendly state. And the reason I was taught that from an estate planning point of view was because the question would often come up is, did you need to prepare a trust for your clients, a revocable trust for your clients, also known as a living trust? Or were you okay with just doing wills for your clients? Because most clients come into the office and say, I need a will. My financial advisor told me I need a will, and here I am. So they come in thinking they need a will, but the question is, do they need something more than that? And back then, the answer was almost always no. Sometimes the answer was yes, but almost always was no. They don't need a souped up plan. They just need wills. And the reason it was probate friendly was it used to be that you could file a petition to get an executor appointed with an original with the original will, and the executor could obtain letters testamentary that same day. In fact, when I used to work at the court, this is the way it was, is that the court was open to the public. You did not need an appointment. You just walked in and you sat outside the door of a clerk's office. The clerk would open the door when she was available, welcome you in, and you would sit there and work with her, give her the documents. And if everything was in order, which not always, but certainly if you had a lawyer helping you, they would be. And right away, they would give you their letters and you'd be in and out within an hour. Sometimes there were delays and it might take a couple weeks, but still not too bad. And as I said, no appointment necessary. And you could just walk right in. Also, before the pandemic, there was an institutional experience that the courts had that I don't believe is there anymore. For example, when I was working there, the judge I worked for was Judge Rosh. She was elected by the people of DeKalb County. But before she decided to run for judge, she worked for the previous judge, Judge Marion Guess, who had been in that position for many, many years. And he had taught her how the court system works, how to do probate work in this community. And she then became the judge after that. She taught me how to do the work. I never became judge, but she taught me how to do it. And I, in fact, taught the person who replaced me in that position, who is still there. So that's one example of a little bit of institutional experience. But I think that has been lost. There's been a lot of retirements. There's been a change in the electorate. So the one with most experience is not always the one who's elected in office. And let's get into post-pandemic, in fact, to talk about that exact issue. One moment. Okay. So probate post-pandemic. It's my opinion from years of experience. All I do is estate planning and probate work. And in the last 5 years, of course, just like all of us, we've all had 5 years to kind of review what it's been like since the pandemic started. It's my assessment that the major counties in Georgia are not probate friendly. They try, but they don't have the tools necessary to be probate friendly. They're overwhelmed by the number of cases they're managing. Some of those cases are disputed matters, like families arguing about who loves mom more and who's going to be her guardian, and mostly who's going to be her conservator, so they can manage her money. That takes up a lot of judicial resources. There are arguments all the time about estate matters, some of them for wealthy clients of ours, some of them for clients for members of our community who don't have much, but whose family is very passionate about the house that's been in their family for a couple generations, for example. That takes a great deal of judicial resources. The major counties have grown in population, and that has also changed how many, not necessarily disputed matters, but just how much of a volume is coming in. There's been a higher number of deaths since the pandemic started, and that doesn't seem to be tapering off with our community getting older and with healthcare issues becoming more of a problem. So they're overwhelmed and they're understaffed. During the pandemic on the outset, just like in so many other places, staff had to be let go. It was a good time to retire if we had clerks who were older, and so they're understaffed right now as well. I want to use, and the reason I say major counties in Georgia are not probate friendly, one, just a matter of disclosure, is I have not practiced in every county in Georgia in the last 5 years, so I can't speak for all of them. I'm just making generalizations about what I do know. But my experience overall has always been that the small counties tend to have a experience that is easier to handle, as I'm sure many of you have experienced in your own lives as well. You can get a clerk on the phone when you're talking about a small county in Georgia. The clerk may just shout to the judge, across the room, and sometimes the judge answers the phone in small counties, in fact. So you get a lot more access. And although they may not have as much experience because their volume is lower, they tend to make the experience a little more comfortable. But I think they also are not the ideal place for our clients to be. So let's talk about Fulton County. Let's go back to major counties in Georgia and how they're not friendly, not probate friendly. I must say that the individuals who work there are quite friendly. I've been in person, I was just there last week, and they are very friendly people. They just don't have the tools necessary. One of the issues that I'm experiencing in Fulton County is that when we need to probate a will and we file that petition, I'm telling my clients right now to wait 3 months before an executor is going to receive letters testamentary. And as you probably have experienced and know from your own financial responsibilities, that accounts are frozen when the owner dies. Again, remember, not joint accounts. If a joint account owner dies, the other remains the owner and it's not frozen. But if you have a single account owner, that account is going to be frozen. And we're all going to wait for court documents, which are the letters testamentary. And it can be a burden on those who have to wait 3 months before they get a document to unlock that account. So in fact, on the Fulton County website right now, they caution, please don't ask us for a status of your matter in the first 45 days after you file. So whereas it used to be, you could go in and get letters on day one, or maybe after a couple of weeks in some of the slower scenarios. Now it's don't even ask us for 45 days how we're doing. And I'm telling all listeners here, it's taking at least 3 months. Also in Fulton County, you now have to obtain an appointment to interact in person with the clients. And this is the same in DeKalb County too. Whereas I said in DeKalb, you used to just be able to walk right in and sit in front of a clerk's door and meet with her and talk about your case. It doesn't work that way anymore. You now need to have an appointment. In Fulton County, where I do more work than I do DeKalb currently, I am finding that they have an online system where you can go online and try to get an appointment. And sometimes it's booked for a week or two from the date that you're looking at. So I will now oftentimes get an appointment that I don't even have a need for. I just go ahead and get it for 2 weeks from now, because I may have a need 2 weeks from now to walk in and meet with a clerk about a matter. We also, now in Fulton County, to their credit, they have something they call walk-in Wednesdays, which is what it sounds like. Every Wednesday you can walk in without an appointment and you can meet with a clerk. I was just there last Wednesday doing that, in fact, and I found it to be okay. I mean, there's kind of a long line of people waiting, and if you miss Wednesday, you got to wait till the next Wednesday. The next bullet point on this slide it kind of ties back what I said a moment ago, is I think there's a lack of institutional experience. Although the judge in the Fulton County Probate Court has now been there for a few years, and I think she's doing her best. She can correct me if she hears this and feels that I'm incorrect in the statement, but my understanding was she did not have probate experience before she was elected. And the fiduciary bar strongly supported a candidate who did have not judicial experience, did have probate experience. She was a professional probate attorney who wanted to become the judge. That one with experience lost the election. The one with inexperience was elected. And she's made some good changes, I think, but she doesn't have, she didn't learn from Judge Toomer, who had been serving for at least a couple decades, who had learned it from the previous judge in Fulton County. So there's sort of a new institution that maybe doesn't have the experience from the past to do the job expeditiously. Also, there have been some serious retirements and reshuffling of clerks. And so I'm finding that we have younger clerks who are working in the probate courts, which I think is a nice thing for the future, but right now also means they lack experience of learning from those before them. In Fulton County, as well as some of the other counties, there's been an introduction of online filing. But I think it's still a little bit clunky. You can file a petition to probate a will online, but you still have to bring in the original hand-signed signature on the will. And you also need to bring in the originals of family members who have been asked to cooperate. So it's sort of like file now, but we're going to wait for you to bring in the originals. Now, I guess if they're going to wait 45 days anyway before they look at a petition, then during that first 45 days, that's when you get your originals in. But I haven't really in my practice found the advantage to that. They also have a kind of an odd rule, which is that if you start filing a matter on paper, you can't then switch to e-filing. So even though in the future it might become, you filed your will and your petition on paper, but then you decide, hey, it'd be great if we could zap a new filing in for something, they'll say, sorry, you got to do it in person. And then anytime you work with government, I'm sorry to say, and this is consistent in probate court and Fulton County as the example right now, is that sometimes the requirements of the clerks seem arbitrary and somewhat inconsistent. For example, it's nowhere in the law that a death certificate needs to be filed with a will when you're trying to probate it. That is nowhere in the law. But some of the probate courts have decided that they do need a death certificate. Okay, I actually think I've actually come around to be in support of that, because there's a potential for fraud if you don't have some proof that a person died. Someone right now might be filing a petition to probate Mark Brandenburg's estate, and I'm sitting right here. So I do think a death certificate is perhaps a useful thing, but what the courts are sometimes doing is they'll read the death certificate and notify inconsistencies between it and the petition that was filed. For example, the death certificate maybe was prepared by a family member in a moment of grieving, and they got the county of residence wrong. They forget, they just, mom always used to live in DeKalb, but yes, she moved a couple years ago to Fulton County, and for some reason they wrote DeKalb on her application for a death certificate. So now the death certificate says DeKalb, and we're filing the petition in Fulton because that's where she lived at the time of her death. Well, now the Fulton County Court is saying that we need to have the death certificate revised, or we need to explain what happened here. So it's things like that that sometimes can gum up the works. All right, let's go through some post-pandemic examples from my practice just in 2024. I have many more to share, but I'm just going to go over what has happened in 2024. We had a divorced dad who died with no will. All right, and he died with a minor child, and he has some assets. He had a townhouse that had some equity in it, had a bank account, had a couple cars. He also had a lot of debt, and like a lot of bills that weren't paid and so forth. And we decided, my client and I decided, that the best approach was to file for years support. A year's support is beyond the scope of this presentation, but just for the purpose of this example, I want to at least go over what it is. A year's support is a share that a spouse or a minor child can elect that will trump a will. So even if your will says everything goes this way, the minor child and the spouse can say, no, 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 it goes this way. And there are some advantages to a year's support that can be used as part of a strategy. One of the advantages is it can defeat creditors. So instead of the estate assets going to creditors, it's going to this minor child. And that is why we follow this strategy. In my experience, a year support petition should take 3 months from the time we file it to the time an award is given. In this case, and this was in Fulton, by the way, it took 9 months. Part of the challenge in this case was that when there's a minor child, the minor child can't receive an award of year support directly. They have to have a conservatorship appointed for them. In this case, the minor's mother, who again was divorced from the deceased, but the minor's mother was going to be the conservator. She's a professional. She has a job. She has her own resources. She could get a bond. There's nothing in her background that would indicate to the court that she was a risk, that she wouldn't use this money properly for the minor child. She's the mother of the child. So a good strategy that I've used for years is to file the year's support and file the conservatorship petition at the same time, understanding that the year's support is going to come first, but we want the conservatorship petition to be right there, ready to go. And in fact, let's already start processing all the work that's needed on the conservatorship petition so that we can do this as quickly as possible. And particularly when we have a minor child involved, we want things to move quickly. The child may need this money. His dad just died. There's a loss of resources there. The court in Fulton refused to handle the conservatorship until the year support was granted. So that took about 6 months. And then finally it was, all right, now we have a conservatorship petition to manage. We had to have a guardian ad litem appointed, which is proper, but it took a lot longer than it should have. At one point during the process, the clerk who was assigned to it wanted some more information about the valuation of an asset that we presented to the court. And in the past, I would feel very comfortable emailing the clerk, and we would go back and forth, and we would get to a result that was satisfactory to the court. And the reason we could do that is because this is not a disputed matter. There's no concern about just being a little informal. But in this case, the clerk required an amendment, which took another week. It took me time to prepare the amendment, to get it signed, to file it. And it's just that kind of thing that just slows this stuff down. And then the last bullet point at the bottom is I filed a bond. The conservator, who's the mother of the child, eventually had to have a bond posted, which again is proper. And I filed it in the North Annex on Roswell Road. And it used to be that there was a runner who would run from the North Annex every day down to the downtown office, so that if you filed it at the North Annex, it was getting downtown within 24 hours. Now they just, every once in a while, seem to send it all by UPS or FedEx or some other mailing system. And it took 4 days. So I really regretted that I didn't just drive downtown and have the client pay for that filing then. But it's those kinds of things that just slow down. And my client has been not upset with me, but has been upset with the probate experience. Another example is a little more straightforward. A husband died with a will. He had a wife who is not the mother of his children. And he had a strange relationship with his adult children. So they were not involved in his life at all. He and his wife did not have much, and his wife needed the bank account to continue paying bills. She was not put on his account. It was a second marriage, and he just didn't feel like putting her on the account, I suppose. So she really needs that money. As you can imagine, his account was frozen at the time of his death, and we needed to probate the will so the account could be unfrozen. So now we had to notify his 6 children, and some of them were not cooperative. One of them had a lawyer contact me and wanted more information about what was going on. Another one returned the signed page we were asking for, but forgot to get it notarized, even though we gave all the instructions and flags necessary to make him see that we needed that. And so it really slowed down the process here again. Also, in this case, this was a will that was prepared out of state, and it was done properly in the state where it was created. But in Georgia, it did not have the self-proving affidavit that is required to make it easier to probate a will. A self-proving affidavit, if it's signed at the time the will is executed, means you don't need to find one of the witnesses who was in the room and find them later when the person died whose will we're discussing. In this case, we did have to find the witness, and we went back to the bank where the will was signed 10 years earlier. Fortunately, we were able to find the notary, and we got it finished, but it's that kind of hurdle that sometimes is not expected with a will. All right, so what are some current methods to avoid probate? I'm just looking at my time to make sure we're on track. Okay, I want to leave a few minutes for questions, so I am going to, I'm going to be aware of that. Okay, so current methods to avoid probate. One is jointly owned assets. I don't love it because, as you can imagine, if you have let's say a husband and wife who own something together, when husband dies, absolutely, you just avoided probate. But wife is going to die eventually, and she's going to be the sole owner of that asset, whether we're talking about the house or the bank account or whatever it may be. So there is going to be probate when she dies before the kids can have access. Now, the access to that asset may not be as important to the adult children as it is between husband and wife, but it still doesn't avoid probate for as long as some other methods do. Transfer on death accounts and deeds. Transfer on death accounts do avoid probate. There's also something there that's not ideal, which is for them to work properly, everyone needs to die in the order that we're expecting them to die. Right? If you have a TOD account that goes to the two kids, great, the two kids will get it. But what if both kids die before the owner? Then where does it go after that? Then it's going to go into probate. Transfer on death deeds is a new thing in Georgia. We just passed a law last year that made it official. The overall feeling about them is that, and this is coming from the real estate bar and also the fiduciary bar, is the law was not drafted well. And we're working with legislators to try to revise the law. So for now, I would discourage your clients from trying to mess with TOD deeds. Another current method to avoid probate is to update your beneficiary designations. Make sure those are updated. They don't have the divorced spouse still on them. They don't have the deceased spouse still on them. Let's make sure that we have those updated. And then a last one that is very popular in my practice is a revocable trust. So what I do with my clients is I identify their assets. I determine what is probate and what is non-probate. So we have our eye on the ball as to what we're trying to address at that moment. We consider what would happen when a joint asset holder dies, if we happen to be relying on that as our probate avoidance method. And then I highly encourage my clients to establish a revocable trust. Revocable trusts do a great job of avoiding probate. In the interest of time, I'm going to just skip through this slide. This is just an example of what a revocable trust is and how it operates, but I don't want to spend time on that because I'm running a little short. Probate, the future of probate in Georgia. So e-filing is promised by the Judicial Council of Probate Judges as something that will be a solution for us. Right now, it's not uniform. And I don't yet know whether it's going to work in the long run as something that's better than what we already have, as long as we still require originals to be proven as valid, as we still require original signatures and original wills. I think e-filing has limitations. There's also some effort to try to bring uniformity among court policies. Each probate court in Georgia has its own judge, and they have their own policies and procedures. And those are not uniform, and sometimes it can be very difficult to practice in them, so that we're kind of trying to figure it out new every time we do something. Some judges, and this may be news to some of you, some of the probate judges in Georgia are not even lawyers. If you're in a small county in Georgia, you're not required to be a lawyer because there aren't enough lawyers in those small communities to staff the judge position. So the non-lawyer judges sometimes handle their affairs differently than the lawyer ones would. And I think there needs to be a customer service mentality that has to overcome government bureaucratic mentality. And then lastly, we need more funding. So that's the future, is we're hoping for some of those solutions. Here's my conclusions, and I'll take questions. Probate is important and beneficial to those who have not planned. We're glad it's here. It is really useful if you haven't planned to try to avoid it. But Georgia is no longer a probate-friendly state. And if you have a client who has the desire and means and wants to try to give a gift to their family upon their death, that gift should be an estate plan that tries to avoid probate. My clients are not having good experiences in the probate court here and would have wished that there was avoidance by their family members. And I think primarily the use of a revocable or living trust, they mean the same thing, is the way to do that. So I please suggest you advise your clients to meet with an estate planning attorney to talk through their own plan and figure out what is right for them. I'm now going to take, in the couple moments I have about 5 minutes, it looks like. So I'm going to see what questions have been submitted. One question, thank you, Melissa, for asking this question, is what about houses that go through probate? Are they frozen too? The answer is yes. Okay, so imagine a single owner of a house, or it could be co-owners of a house where they own it as tenants in common. So you have to look at the deed to know whether a house is owned as joint tenants with rights of survivorship, or if it doesn't have that magic language, then it's owned as tenants in common. Okay, so, but let's just, for sake of your question, imagine a single owner of a house. That owner dies, the house is frozen. The house cannot be sold. The house cannot legally be rented, although this practically it often is rented, but you couldn't legally sign a new lease. The house can't be refinanced. All those things are going to be prevented until probate is unlocks it by having letters testamentary given to an executor. Another question was someone, Harlan, would like to know a little bit more about TOD deeds. All right, let me just read the question. Okay, so the owner, the question is, some people are doing TOD deeds to try and make it easier for their survivors to inherit. The issue with the TOD deeds is that there's a lot of questions that aren't answered about process. Okay, one of them, and I think the biggest one, is that you execute a deed that says, upon my death, I want the house to go to my son. Well, your son has, or my son has 9 months after the date of my death to file something in the public record saying that they are receiving this house. And if they don't do that, then they've lost the ability to get the house through this method. So the 9-month thing is kind of quick. And does my son even know they need to do this? If they don't have legal advice, maybe they don't. There's a whole lot of other questions that are outside the scope of this presentation, but thank you for asking that. And also, I'm going to look in the chat and see if there's a couple other questions. I think there are. Let me just peek at that. All right. Oh, I'm sorry. I think I was looking in the chat for the first questions. All right, I'm going to the Q&As. I'm going to ask those. All right. What are my thoughts on the legislation passed in 2024 allowing TOD designation? I think I already answered that one. Please explain again why you don't recommend transfer on death deeds. Everyone has questions about those. Do I prefer an individual trust or corporate trustee when a client passes? Good question. That's a tough one. I still prefer individual trustees because I think those are the individuals who are going to work the hardest with the least amount of pay for a family member who died. I do think corporate trustees can be really useful, but they're expensive and they don't take every case. They usually take the higher wealthy cases. And so that sometimes is a challenge to many of our clients. Let's see. I have a client that has a 17-year-old teenage son. Okay. All right. So the question is, if you have someone who is almost an adult, maybe 17 years old, who has a disability to the level like autism or Down syndrome, do you need a guardianship and a conservatorship for them? The answer is yes. And it is the probate court in the county where they live that will appoint that person for them. That's an example of when the probate court is there to protect those who cannot protect themselves. And then I think this is the last question I have time for. Do you advise do I advise joint revocable trusts or a revocable trust for each separate party? Different lawyers think differently about this. I prefer separate revocable trusts for each spouse. The reason is that the joint revocable trust is really just a fiction. And the fiction is that you're going to have two silos within the same trust document, and a husband and a wife, or a spouse and a spouse, are going to keep those silos separate and keep their assets separate. And it's rarely done that way. So it's really just a fiction that I think is better to have separate trusts. All right, I think I've run out of time. I'm going to hand it back over to Kathy to make some closing remarks.
Thank you so much, Mark. This was a very informative presentation, and we appreciate your time and expertise. Thanks to everyone who connected with us today, and look for an event survey, replay, and this deck from Mark to follow. Thanks, everybody. Have a wonderful afternoon.
Thank you. Bye-bye.
Thanks again, Mark. Bye-bye.